Hi, I'm Patton, neurologist in Houston, Texas, and current chair of the Medical Economics Committee of the Texas Neurological Society. I'm excited to bring you this edition of the Business of Neurology. The Business of Neurology is a video series that's sponsored by the Texas Neurological Society. The goal of this series is to help members understand certain business aspects of the practice of neurology. In this episode, we'll be talking about contract negotiation and specifically non-compete clauses. As physicians continue to either sell their practice or go into employed situations, this topic becomes all the more timely. Contract stipulations such as non-compete clauses are all the more important. Today, we'll be talking with Stuart Miller. Stuart is an attorney with Munsch, Hardt. He received his Bachelor of Art from Columbia University and a JD from the University of Texas School of Law. He represents healthcare clients on a number of corporate and regulatory matters. Chambers USA Texas, the Best Lawyers of America, and Texas Super Lawyers have all recognized him as a leading attorney. He has served as president of the Greater Houston Healthcare Alliance and as chair of the Houston Bar Association Health Law Section. Previously, he was an adjunct professor at the University of Houston Clear Lake, where he taught for over 10 years on graduate level courses on the legal aspect of healthcare administration. Stuart, welcome, and thanks for letting me interview you today.
My pleasure, and happy to talk on non-competes or any other kind of legal or business issues that might be of concern to neurologists. There's a lot happening in healthcare. It's obviously a very heavily regulated industry with a lot of change going in, and so there's a lot that we could hit on today.
Absolutely. I think this is going to be very interesting.
Yes.
You know, you're absolutely right. There is a lot going on. I remember years ago when the number of physicians going into an employed situation just hit 50%. Now I think it's in excess of 70+%. So, and physicians are having to go into more employed situations, whether it be with a large system or a private equity firm and so forth. So, very timely topic. I did want to open up by giving you a chance first to give some general advice to physicians when they are going through employment contracts, things they should look for.
And I have a whole PowerPoint that I can email you later on this. This is the topic I've given to kind of residents and fellows probably every year for the last 20 years. And I'll tell you, the first thing I would look for, and I'll say the doctors, when they get it, and because they're human, the first thing they see is the dollar sign, right? What is the salary? But this is why I joke that lawyers are not as much fun at parties as we were before we went to law school, is because we start thinking of what is the worst case scenario. How, if everything, ideally you're going to go work at this job and you're going to love it and you're going to be there for 40 years and they're going to give you a little gold watch when you retire or whatever it is and all will be well. But doesn't really happen much anymore. There's a lot of movement and people kind of go from place to place for all numbers of reasons. And so you have to think, okay, if I'm no longer happy here and I want to move, what are my options? It could be you love it here, but your spouse or partner gets a job in another city and so you have to move. And are you able to do that, right? Or what happens if the practice gets sold to private equity and you love it when Dr. Patton was in charge, but now there's some MBA from New York who's in charge and is, even though they say nothing's going to change, things have changed, right?
Absolutely.
And so you're like, this isn't what I thought I was getting into, I want to try something else. Or it's just you have a child and you want to scale it back, and so then maybe you decide you're going to go work for a hospital system where you can be part-time and not be, this 80 hours a week, which, doctors used to kind of pride themselves on, who works the hardest? I never even, went to one of my kids' games, and now,
never take a vacation.
Never take a vacation. Big deal. Is that going to be on your tombstone, right?
Yeah.
That's not such a great thing to be proud of. But now, and this will come off perhaps as sexist, but it's the truth that now more than 50% of med students are women, and I think women, rightly so, are putting perhaps more of a priority on having a life outside of medicine, and so there is a kind of more of an understanding that that's something that needs to be considered, and so there are more flex time and part-time schedules, but there's still only the same number of residencies. A lot of times there need to be more residency programs. There aren't enough doctors out there, and so those are issues that come up. But getting back to what should the young doctor looking at their first employment agreement look for is say, okay, if things go wrong, what right do I have to terminate without cause? But at the same time, what right do they have to terminate without cause? Because it's going to be mutual. What happens in the event of termination in terms of tail insurance? Who's paying for it? And what about the non-compete, which is what we're talking about? And non-competes generally vary state by state. And I remember, I'm old enough to remember when the law changed before, and it used to be that, I guess, there was a non-compete, and the law changed such that in Texas Business and Commerce Code 15.50b, and this is like the one statute I know by heart that I can sound like a true dork for because we've had to deal with it so much, the Texas legislature, which are, no offense if like your brothers in the Texas legislature, but they're kind of idiots, they changed the law and they said, okay, for a non-compete with a physician to be valid, it has to have this language in it. But it just said a non-compete with a physician, so theoretically you could be a non-compete with, if we were in business together owning McDonald's, the non-compete would be valid for me and not for you if it didn't have this magic language in it, right? Yeah. Or if we owned an apartment building, right? Because it just said a non-compete with a physician, not for practicing medicine, not for, but it was for a public policy reason. It said the doctor should have the right to buy it out and should have the right to continue seeing the patients that are in an emergent condition. So you can't see them forever, but if there's, and it's because the law doesn't care about the doctor and it doesn't care about the employer. The law, ostensibly is drafted in order to protect the patients, right? If I'm a patient and all of a sudden, I've had this doctor that I've had throughout all my illness and I'm sick, I don't want to call him up and he say, I can't see you anymore. I had a non-compete with Dr. Miller and he says I'm not allowed to talk to you or I'm going to get sued, right? Wow. And so they put this law in there and then, or they changed the law, and so then essentially every non-compete that didn't have this language in there, this magic language, was held to be non-enforceable, right? So then all of a sudden you would have these old employment agreements and someone would try and leave and the person said, we've got a non-compete, and you'd say, oh, it's not enforceable. You didn't put in the new language, right? It was, in a way, it was a great project, money maker for lawyers, because I was like a young attorney then, and we sent out like a letter to every client, hey, you might want to amend your employment agreements, and it was, then the ones that bothered to read their mail would go back and we created work for us, the other ones didn't, and then they would call upset when someone went across the street and opened a business just because they didn't have a valid non-compete. Now, Biden, or not, it's not Biden by himself, but the FTC, after Biden, talking about it, issued this thing kind of banning non-competes.
And we're going to talk about that, but I want to back up a little bit.
Okay.
No, I think you're absolutely right. And I remember coming out of fellowship, my first job I took as an employed physician. And you're right. I saw the numbers, and I really didn't go past that first, amendment where it showed the salary. But once I did a very smart thing in that the local county medical society told me, hey, you need to have a lawyer review this, not just your friend or family member, but have someone who knows about healthcare. And that was my first introduction into non-compete clauses, non-solicitation, and so forth. But maybe you can, because some people may not know exactly some of the history that you were talking about. What specific is a non-compete clause, and how does it benefit, employers?
Well, it benefits employers, and then it can, work to the hindrance of the doctor. But it's supposed to be reasonable in terms of time, scope, and location, meaning that I can't say you can't work anywhere doing anything for the history of time, but I can say you can't work as a neurosurgeon for the time of this agreement plus 2 years thereafter within 8 miles of this office, right? Because you could go and be a internist if you wanted to. You could go 15 miles away, and you can go, come back 2.5 years later and be across the street. We're not keeping you from, having a livelihood, but we're just saying we don't want you to take, meet all of our patients, learn how we do everything, and then be across the street. Now, what is reasonable in terms of the restricted area also varies depending on what city you're in, right? Because really it's from where do you draw patients. So if you're in Houston, it might be one thing. If you're in, Amarillo, there probably aren't as many neurologists, so you're probably drawing from a wider radius, right?
Absolutely.
And then we've had somewhere, say it was and this isn't neurology, but it was, a non-compete, say, for a doctor that did IVF. And they'd say, okay, well, you can't do IVF, but you could be just a regular OBGYN, but you can't be doing IVF in this area. And so you can figure out how to, depending on which side you're on, whether you're representing the employer or the employee, carve it to make it as broad or narrow as you like. And then the courts in Texas have decided something which I think is a very bad ruling, but I'm not in charge, is they said, okay, in one court case, and I forget the name of the case, but it's unimportant, they said, okay, if it's too broad, we understand though the intent was to have a non-compete, and both sides agreed on that, so we'll, what they'll call it, blue pencil it and kind of revise it to make it, if it was too broad, we'll narrow it to make it as broad as it could be within the law. But that gives a perverse incentive to the employer, because if I'm the employer and I know that the law will do that, well, then I'm going to write it as broad as I can, knowing that the judge will just narrow it. Why would I even try and narrow it and make it reasonable? I'm going to try and make it ridiculously unreasonable and figure then they'll just narrow it this way. If I start here, I might be, only hurting myself. So I think that was a mistake, but no one asked me other than you, right?
So what I'm hearing is there are three main things. There has to be a reasonable geographic area. There has to be a reasonable amount of time, and that these are at least negotiable, and you can even negotiate it out of the contract depending on how
much leverage, right? It's all about leverage, right? And they need to give you some confidential information. If they don't give you this information, then you can argue that it's not enforceable, because you have to get some consideration, which is like a law school 101 contracts term. In exchange, I'm giving you X and you're giving me Y, and there has to be something besides the job. That's not sufficient consideration. But and then what some people do is they'll say, oh, I think this one's so overly broad it won't be held to be enforceable, so I'll sign it knowing that the courts are going to toss it out. Or, if sometimes people would find one that didn't have the magic language and they'd go, oh, yeah, we'll sign that because the courts are going to toss it out. But I wouldn't advise doing that, because even once you get to court, I feel like you've almost already lost.
Yeah.
No offense to my law partners that are litigators, because it's expensive, it's stressful, and maybe that's why I'm not a litigator. They love a fight, and they will go in there, and it takes up a lot of your time, and it's, no matter how quick you think it will be, it will always take longer, because the courts are so backed up, and people can drown you in paper, especially if you're, one guy, Dr. Patton, and you're against, HCA or something. There's no way you can win, right?
Yeah.
Because they've got an unlimited budget.
So these are enforceable, because some people think, well, they're not enforceable anyway. And the way I explain it when I'm doing lectures and so forth in this arena is that, you can fight it, but as you said, do you have the money to compete with, this larger system? And that goes into like the buyout and all the other things that you can have.
And then, they can try and, I'll get a temporary injunction saying, okay, the person was across the street, and therefore we're going to, stop them from doing it. This is a total tangent, and maybe we'll cut it afterwards, but I recall one time, I'm not just having a flashback to it, as a young associate, did you know Ivan Wood?
The name sounds familiar.
He was like maybe 6'5", 350 pounds, with a voice you could hear. If he was in Houston and he's talking, we could still hear him here. He's kind of like the godfather of healthcare law, and he was my mentor.
Yeah.
And he, I owe much to him, but he could also scare the hell out of you, right? So made many an associate cry. So one day he calls me, he's like, Stuart, come down to my office. And he's like, Cole, your insurance, you committed this malpractice and whatever it was. And it was that someone had, this orthopedic surgeon had opened a practice across the street, and in their employment agreement, where it talked about the buyout, it referenced the wrong section. So I'm like, oh my God, did I make a mistake? I look on the system, I found out I had done one agreement for this, we'll call him Dr. Smith. He took the agreement I did, tried to copy it. When he did it, he messed with the sections.
Oh.
And so then his homemade one referenced the wrong section. So I'm still waiting for my apology, but I'll wait for that till the day I die. But the person ended up buying out the non-compete, and this lawyer wanted to say, no, I don't want to take the money. I want you not to compete. And we said, no, the law says that you have to put the right in there, and if he brings you the check, it doesn't matter that you didn't deposit it or cash it. He can be across the street, right? And so that's what ended up happening. But I will tell you that I had a little, heart palpitations for, an hour or so before all that came to fruition.
Well, I want to go back now to, you started to touch upon this, and this is really timely as of when we're doing this interview here in July. But earlier this year, the Federal Trade Commission voted to ban non-compete agreements. And I was wondering if you could tell us, how does this apply, first of all, to physicians? And then what does it mean specifically? Is this going to affect non-competes that are in place now? Is it non-competes moving forward? And we'll get into some state stuff later, but just can you touch on that ruling earlier this year and what that means for us?
Well, I'll give you the worst lawyer answer, and that's it depends, because part of it has not yet been determined. So what would it was supposed to be after the FTC came out with the ruling, and they voted, 3-2 on this, and it was supposed to go into effect on September 4th, is that all non-competes would be invalid unless it was with an executive making over, 180 something thousand with decision-making authority. So if you were a doctor making over 180, but you weren't kind of like on the board of the company, your non-compete would be invalid. And they were saying that all employers were then going to have to tell the employees that their non-competes were going to become invalid come September 4th. But one interesting tidbit on that is that the FTC does not have control over nonprofits. So if you were employed by what we used to call kind of a 501A, but now it's like 162B under the Texas whatever occupations code, kind of the nonprofit healthcare organization, then it wouldn't be applicable, or it's debatable whether it would be applicable. But the way it's written, it wouldn't be, and one would think that might be a kind of a caveat that they gave to the large hospital systems, so that the large hospital systems, say like in Houston, a Baylor or a Methodist or whatever, they employ doctors through their nonprofits. But if you've got a private practice, you're a for-profit entity, and so you wouldn't be able to have a binding non-compete with the doctors, but Baylor or MD Anderson, the ones that don't need as much help, would, right? So, newsflash, the world isn't fair. So that's part of it. But then there was a lawsuit that was filed in the Northern District of Texas, and they enjoined the enforcement of this, of the law, and they said they were going to come out with a ruling by July 23rd, which is, I think...
Next week?
Yeah, next week. So, and then, but then they said, okay, maybe this will only apply to this one system. There's another lawsuit in, I guess, another state. I'm forgetting which state it's in now, but, this one in Texas would be kind of the one that I'd be focusing on more likely. And we'll see where it goes, because they're trying to say, okay, this is restraint on our ability to contract, right? We entered into this contract. We gave them something, they gave us something. How can you come in after the fact and kind of tear up the contract we had? And so we'll see where the courts come down with it. And if you go to 10 conferences in healthcare law, you'll get 11 opinions. But the overall deciding one where people think it's going to come down is that they'll for sure get rid of the non-competes for kind of the lower wage employees. Okay. I mean, I had some where the doctor, it was like, oh, this receptionist is now working for this other doctor, and I don't want her to do that. We're going to kind of go after her. I'm like, she was making, $15 an hour. What confidential information about your business does she have? I mean, there's no, it's like, oh, but I just don't want anyone else to then think they can go and work for that doctor across the street. I don't want them to take my biller or my coder or my, nurse practitioner, so I want to go after her. And I'm like, that's not what these rules were intended for, right?
I certainly understand from a business standpoint, and it affects not only just the large system, but if you are a small independent practice and you bring a doc on, it would benefit you pour money into training or getting that doc ready. You want to try to protect that asset until you get a return on your investment. But.
And because a lot of times the first year they're not really profitable, right? Or if so, it's barely break even by the time you pay a moving expenses and a recruiter and a signing bonus, and you got to, kind of walk behind them to teach them how to document things and record things properly. It's the same with lawyers. So one thing that you can do if you're the employer and you're like, okay, say they come out and say, non-competes are done for, or if now it's just so much on everyone's mind that the doctors are like, I refuse to sign a non-compete, right? And we're getting that a lot, on both sides. We say that if we're representing the employee, when we're in the employer, sometimes we hear that. But if you're the employer, one way you can kind of get around that is to say, okay, we're going to have a longer-term employment agreement where you're not able to terminate, where the employee is not able to terminate without cause.
Okay.
And so they can't just quit and go across the street. Now, if they, get disabled, or if, and you could make an exception if they move to another state, to take care of an ailing family member, you're not going to probably go after them. But if they just decide, okay, we're going to quit and go work across the street, you'd have the ability to sue them for breach of contract, because not for violating the non-compete, but they breached the termination provision, and then you could say, okay, what are our damages? If you breached and you still had a year and a half left on the term, we were expected to make this much money from you over the next year and a half. Those are our damages. Or you can even put in a liquidated damages clause and say, if you breach early, if you breach by terminating without the proper notice or whatever it is,
sure,
you're going to have to pay this agreed upon amount in damages. And that's enough to kind of make them stay, or enough to, because you don't always want someone there who's doesn't want to be there, but at least then it covers you so that you've got the money to go find a replacement.
Sure.
Yeah. And
with this federal ban, with the Federal Trade Commission, how does this affect the state? Because several states have already either gotten rid of non-competes or said they weren't enforceable and so forth. So what will this mean for states who are in their own state legislation or House and Senate plan to go after non-competes in the future?
Well, if a state's already banned it, then it's...
Well, the states that haven't, rather.
Right. So the states that haven't, so Texas hasn't banned it, but it's, has its own rules on it. The federal law can essentially, whichever law is more lenient to the employee, not the employer, on kind of doing away with non-competes would control. So if the federal law prevails and says you're not allowed to do any non-competes, all the non-competes in Texas, despite what the legislature says, would be tossed out. If they come and say, it's somewhere in between, a state could then come in and say, well, we want something even more worker-friendly than the feds came with, and do that. The one interesting bit, and this is getting into maybe more law dorkiness than the audience cares about, is there's a recent Supreme Court case where they kind of overturned this, what they call like the Chevron doctrine, which was, I think, from a case in 1984, which gave powers to federal agencies to kind of draft regulations that related to kind of what they had control over. So the EPA could draft regulations about environmental issues, or the DA about that, and they were given like almost like a presumption of constitutionality. It's a hard word to say, because these were supposedly the experts in the field and all this, and so there's kind of the right-leaning justices are kind of maybe anti-regulation, and so they're saying, nope, these aren't elected officials. They don't have the right to pass any of these laws. So even if the FTC, I think if it were to go up to the Supreme Court, prior to this past year, it would likely have been held, that okay, the FTC could make that ruling. After this most recent case, and I'm blanking on the name of the case, I just remember it overturned the Chevron doctrine. It had some long name, but it was 6-3 decision that they'd likely say that the FTC doesn't have the ability to do that, is what some people are thinking they'll come out with, but that could get pushed back, or will they then say, okay, we're going to kick this to Congress and try and get Congress to pass a law doing it as opposed to the FTC, because the question is who really wants there to be non-competes? I mean, I guess it's the large corporations, so maybe they'll say, okay, they'll end up with a law so they can say they did away with them, but it's, we'll have a lot of caveats, because another caveat was, okay, if it's for the sale of a business, then you can have one. Because say we were talking about this before the camera started rolling, say someone sells their practice to private equity, right? Well, if you were to do that, and that's, as I said, probably 75% of the junk on my desk right now is people selling out to private equity, and you're going to have a purchase agreement, and within the purchase agreement there'll be a non-compete. You're going to have an employment agreement, and there's going to be a non-compete there, and then they're going to pay you partly in cash and part in stock, right? Normally it's like a 70-30, because they want you to be motivated for the company to be profitable going forward, and so you'll have this ownership in what they call rollover equity in the management company. And within the company agreement of the management company, there'll be a non-compete there. So they've got 3 bites at the apple to kind of lock you in. So even if and then there have been cases that say that language in the non-compete that I was making fun of the legislature about, because it just said non-compete with a physician needs to have this magic language. Then a judge has said, yeah, we screwed up, or the legislator screwed up. That really should only apply if it's an employment situation.
Sure.
So if it's a bundle of docs own real estate for a medical office building, you can own another medical office building 5 miles away. You just can't practice. So, but if you own the management company, theoretically you could own, you don't have to have that buyout language. Or if it's in the sale of your practice, we could say, well, okay, they don't have to have the buyout language. But in the sale of the practice, a lot of times to CYA, they might put in the language. But if it's an employment agreement, it has to have a reasonable price. Again, reasonable coming back up, and reasonable is typically thought to be 1 or 2 years' salary. But if it's a buyout in the event of a purchase agreement, often the buyout is the purchase price of your practice. So some people could sell their practice for $20 million or $40 million. Now all of a sudden, to buy out the non-compete, no one's going to write a check for $40 million to buy out their non-compete. I mean, that's insane, but it makes sense, because if I'm some private equity guy and I'm buying your practice, I don't want you to then quit a week later and go across the street, because what the hell did I buy? Right?
So what else are you seeing in practice, specifically around the private equity?
I mean, there's that, and then every doctor that I talked to was like, oh, I wouldn't tell my kids to be a doctor. It's so much harder than when I went into it, and you don't make what you used to, and they're all like wanting me to hold a telethon for them or something like this. So, but the truth is that most don't make the majority of their money just from patient encounters, right? So they have to have, invest in whether it's a surgery center or a lab or a pharmacy or a medical office building or dialysis center or some medical device or, you name it. There's wound care is very hot now. Once upon a time, compounding pharmacies were hot. There's always the latest exosomes or, everyone's got a way that AI is going to, some software with AI that they think is going to change how it's healthcare is practiced, and that I should invest in that. And I'm not. But someone's going to make a bundle on it. I don't know enough to know which one is going to work. So I'll just keep my money under the mattress. But the trick is on all those. There's a way to do it legally, with fraud and abuse rules, Stark and anti-kickback, and there's a way to do it and get in trouble. And I always find it shocking at times. I don't know if it'll sound a mixture of cynical or naive, that some doctors will risk their license and their livelihood for like an extra, 10, or $50,000, or you're like, okay, they're offering you this medical director agreement for a place that you've never been, where you don't do anything, but you refer some stuff to it. So they said, well, you review this. I said, yeah, you can't do that. So you're not actually doing the services. And I said, yeah, but it's just a small amount, no one will know. I said, well, then you'll just go to a small jail that no one will know about, right? Don't, if it sounds too good to be true, if you're getting paid to do nothing, that's a problem, right?
Absolutely.
We'd all love to get paid to do nothing. It just, and things that
doesn't work that way in the real world.
No, but the things that make sense in the real world and any other business are illegal in healthcare, which makes it unfair to doctors. Because if the doctors are the ones that really control the patients, right? So if you're sending it to, whether it be a lab or a pharmacy or whatever the ancillary services, they're going to go wherever you tell them to go because your patients trust you, right? And that's charging infinitely more than you're charging a lot of times for the patient visit. It can be frustrating that, in any other business, where if you're the owner of this imaging center and someone sends you a lot of business, you'd want to thank the person. If someone sends me a lot of business, I want to take him out to dinner or, take him to a ball game or something. If you do that in healthcare, that can be viewed as a kickback and get you in trouble, right? We knew of a case. Now, granted, this is to an extreme. There was a group of doctors that were taken on a private jet to the Masters. And on the plane, apparently, they got drunk and were kind of abusive to the pilot, or co-pilot, one of them. That person, I guess, was telling some friend about this. The person said, oh, they're not allowed to do that. And turned them in as a key tam. And the hospital and the doctors got in trouble. Oh, wow. And because, it wasn't just like, hey, we're going to, see the Spurs play the Grizzlies. It was, the Masters on a private jet. They go, this was not just a friendly gesture. This was done to induce them to refer. Sure. And that was viewed as illegal.
Wow, we covered a lot of very interesting topics, and I appreciate your insight in these very timely and specific topics dealing with contract negotiating and specifically the non-compete. So thank you again.
My pleasure. My pleasure.
Today. All right. Well, I hope you've enjoyed this edition of the Business of Neurology. Please stay tuned to the Texas Neurological Society website for future installations into the video series.